SJC-11176, Commonwealth versus Muller.
Ms. Thurber, good morning.
May it please the court. My name is Deidre Thurber. I'm appearing on behalf of Christian Muller. I want to start off by apologizing to the court for some of the inarticulateness of my brief. Now that and I'm also going to continue the confusion we have about Padova. In listening to the prior argument, it appears that the instruction giving in Mr. Muller's case concerning intoxication and his mental illness is very similar to what was given before. However, he was tried in between the Berry cases and the Padova case, and as the court's rule is, he's entitled to the ruling in Padova because his case was pending at the time. I believe, if I understand Padova, and it's a struggle for all of us to understand, it appears to me that Padova holds that where a defendant has a mental illness and he used drugs at the time of the crime, he is entitled to a charge that if the mental illness created a lack of responsibility, lack of criminal responsibility, the use of drugs that aggravated the illness did not negate the defense of the lack of criminal responsibility. And Mr. Muller was not given that instruction in this case. He was given the instruction about activating latent mental illness, which this court has specifically in that footnote in Padova renounced as being confusing and inappropriate in jury instructions. So I would ask the court to uphold and continue that ruling in this case and reverse Mr. Muller's conviction for that fatal flaw in that instruction. As to my next issue.
Well, on that one, though, it seems to me that the instruction, you know, it wasn't the Padova instruction, I get that, but it did suggest that if the disease or defect made him lose if using the drugs activated the mental disease or defect and made him unable to conform his conduct to the requirements of the law or appreciate the wrongfulness of it, he would lack criminal responsibility. And the exception would be if he knew or had reason to know that his use of drugs would do that. So doesn't it cover both? Not as articulately as one might wish, but doesn't it cover both?
But it leaves out the instruction that if as I started off my comments with, it leaves out the instruction that if he did have a mental disease or defect at the time and he used drugs at the time of the crime, he's entitled to a charge.
Well, didn't he say you may consider whether the defendant had a mental disease or defect apart from his drug or alcohol addiction?
Yes.
So it's not foreclosed in this instruction.
No, but I struggled with this, the way it's interjected in the middle of this talk about alcohol seemed to me to raise the issue is for you to decide whether or not he had a mental disease or defect.
In my memory is that there was no objection to this instruction?
There's no objection to the instruction. I found that where that was interjected in the middle of the instruction to make it unclear as to whether or not the judge is saying, you know, you can decide whether or not he had a mental disease or defect or he didn't have one and alcohol gave him one. I think it's very unclear.
There was also evidence, wasn't there, that the defendant was aware that when he consumed drugs combined with his mental illness would cause him to lose capacity to conform to the law?
There's no evidence that he knew. There's evidence, I mean, people talked about the fact that
he told the police that.
But if you look at the entirety of that statement that he gave to the police, there is obvious police prodding, pages and pages of police prodding to get him to say, the drugs made me do it, the drugs make me crazy, I can't control myself when I take the drugs. So much of what he said to the police, at 163 pages of police testimony, of statement, was in response to feeding into what the
But I
police
think the
were.
question was there evidence? I mean, you would have to say there was evidence. You would say it's not fair to credit that evidence, but there was evidence.
I don't know that there was, I don't believe there was evidence that he ever articulated or knew some of the effects that the alcohol, that the drugs could have on him, because my recollection of his statements about taking the drugs were because they helped him sleep. They helped the voices recede. That was, my recollection. It was until he got into the police statement that they started to encourage him to tell them that the drugs made him crazy and he couldn't control himself when he took the drugs. Prior to that statement, there's nothing that any of the family or friends said that indicated, or even the various psychologists that testified, that indicated that he knew that the taking of the drugs made him violent on top of his mental illness.
Now, the primary concern of Berry and DePadova, especially where there was no objection, was that the jury may misunderstand or arguably think that the mere fact that he voluntarily took alcohol or drugs somehow negates a insanity defense. Do we have that here?
I believe when there's been no testimony during the course of the trial about anything being latent, I think that that's a confusing thing. For all of a sudden in the middle of the jury instructions to interject this idea that it's a latent mental illness and that the defendant may not even be aware of the fact that he's got a mental illness. So yeah, I do believe it can be misconceived by a jurors, especially, say, in the context in which this was written, when they go on to say, the judge goes on to say, if the Commonwealth has proven beyond a reasonable doubt the defendant knew or had reason to know, then you must find him criminally responsible. There's not even it's a presumptive that you must find him guilty.
And instead you say he should have said should?
May. As to the issue of the instructions, and I apologize for the dearth of authority that I can point the court to. However, in my experience, I have never experienced as a trial attorney or as an appellate attorney, a situation in which when a judge is giving instructions on each and every element, or the counts of the crimes charged in each and every element, that at the conclusion of giving those, there's not an instruction given that if the Commonwealth has proven each and every element beyond a reasonable doubt, you may, should, shall convict. However, if the Commonwealth has failed to prove any element beyond a reasonable doubt, you must acquit.
Didn't that come at the beginning of the instruction?
That came when he did the count. Oh, you mean the general overall instruction?
No, maybe I'm confusing this with, I thought the instruction was, here are the elements, the Commonwealth has to prove beyond a reasonable doubt each and every one of these elements, A, B, and C, and at the end, the judge says, if the Commonwealth has proven A, B, and C, you shall find him guilty. Is that what it was?
Yes, but
But you're saying it was missing, if they haven't proved A, B, or any one of those, you may not find him guilty.
Right.
But if correct me if I'm wrong, but I thought that the failure that you point to related to some of the offenses, but none of the homicide offenses. Is that correct?
none of the homicide offenses.
It's home invasion and assault with intent to murder and...
The firearm, voluntary manslaughter and the firearm.
So with respect to the homicide offenses, the judge's instructions met the standard that you are advocating, correct?
Correct. But we're talking about, there were 7 charges against the defendant, but the judge gave instructions as to 9 because of lesser included or different theories. But, so we're talking about errors in 5 of those 9. In 2 of the cases, in 2 of the instructions, he gave presumptive instructions that you must find a defendant guilty, not that you may, shall, or should. And in the other,
2 of those 5.
yes, and in the other 3, failed to give the corollary. In one instruction, the firearm instruction didn't give either instruction that you know, you must find him not guilty or you may convict. But in the other 2, gave the, you should find him guilty, but never gave the instruction about you must not convict.
And I gather no objection.
Correct.
And where the jury found him guilty of the charges that were not tainted by what you claim to be this misuse of language, why should we say it would have made a difference?
They found him guilty of all of them.
I know, but my point, I guess my question is, since they found him guilty of the charges where the judge did tell the jury, if you do not find him guilty of all the elements, you must find him not guilty, and then found him guilty as to those, given the nature of this particular offense, why do we think it could have possibly made a difference as to those counts that you're referring to?
In one of the instructions that was improper, my allegation is improper, was the home invasion, and that was the basis of the felony murder conviction. So if the home invasion conviction is faulty, then the felony murder conviction would be faulty as well.
But he was found guilty of premeditated, wasn't he?
Correct.
And this extreme atrocity also.
No extreme
Oh.
atrocity, no. Just premeditated,
So,
just.
so it wouldn't help you.
I think it's a pervasive constitutional deprivation. It's a deprivation of his constitutional right for the instructions to be accurate and fair and to provide him with his due process rights, and that we can't be sure what the jury understood or didn't understand because of the discrepancy in the way he charged the jury.
No, judges obviously instruct in many different ways. Some front load that language and some do it at the end as a wrap-up, and some don't at all, including in the model homicide instructions. But have you found any case law, what do you cite to us as opposed to just the Commonwealth's burden, of course, to prove beyond a reasonable doubt the constitutional burden? Have you found any cases or any place else we've said here's the preferred order in which a judge should instruct?
No.
And what would you have us say in that regard?
I would, that in each and every count of a charge of a judge to a jury, the jury must be informed that if all the elements are proven beyond a reasonable doubt, they may, shall, should convict. However, if any one of the elements are not found beyond a reasonable doubt, they must acquit.
In fairness, the judge should give the corollary
Correct.
language at a minimum.
Correct. And I mean, think about the prejudice to a defendant when the judge only gives the language about you must or you should convict, but no language about acquitting. And that's exactly what happened here. He failed to give the language about acquitting in 3 of the 9 charges that he gave to the jury. The only case I can find that I can direct you to at all was the Commonwealth versus Lopez, which is an appellate court case, Court of Appeals case. And the quote there was, "As to be sure, the jury instruction should be clear at every point in the absence of a finding that each element of an offense is proven beyond a reasonable doubt. It is mandatory that the jury verdict be one of not guilty." And that's in my brief, but it's 87 Mass App Court 642. This has been my first experience in all the years that I've done criminal law that I've ever seen a situation where the corollaries were not given. So it was hard for me to find authority for me to present to you. The next issue I raised was the issue of the prosecutor's summation, especially as the prior counsel pointed out, in a situation where the sole defense to a case is a lack of criminal responsibility in this day and age where so little is understood about it and the public is so unwilling to, I believe there was a spotlight, the Boston Globe's done a spotlight on how many cases have raised the issue of mental disease or defect and how many have been successful, which is virtually none. That there is, especially in a case like this, when the defendant's guilt, his factual guilt was not contested during the case, and 2 people are dead, and jurors want to hold people responsible for that. I think under those circumstances, those of us who work in the system have to be very thoughtful and careful about the language we use. And the prosecutor in this case used language that his mental illness defense was a crutch. He talked about him not being a raving lunatic, as if that's the only way you can have a mental disease or defect, is if you're a raving lunatic, or not being shut up in a dark room. Those were all words and phrases that demeaned and undercut the defendant's defense of mental disease or defect. And there can be no question, I believe everybody agreed, that he suffers from a mental disease or defect, which he has suffered for many years, going back to when he was probably, I believe 14 was the first time he was diagnosed. He started taking drugs to deal with the voices he hears at the age of 9. I said, there's really been no contention during the course of the trial that he did not suffer from a mental disease or defect. So to use that kind of language in summation, I suggest is extremely improper, especially since the sole issue at the trial was his lack of criminal responsibility based upon his mental disease.
And I gather no objection?
Excuse me?
Well, I gather there was no objection?
There was no objection. I don't know if it shows up in the record, but apparently during the course of this trial, the trial attorney, Mr. LaChance, was ill. And I believe there was some time taken off during the course of this because of his illness. I don't know how much that impacted him, but I think that might be a reason why, as the court keeps pointing out, much of this went through without objection. There was also an improper vouchering for credibility of witnesses. As I said, the only issue was whether or not his mental disease or defect rendered him not responsible. And yet the prosecutor vouched for the credibility of the eyewitness, vouched for the credibility of one of the psychiatrists when their credibility wasn't an issue. There was also...
I'm sorry, so if it was not an issue, why is it going to be a substantial likelihood of a miscarriage?
It adds to the whole tenor of the summation. It's just one portion of the summation that just goes, that was unnecessary to be said, had nothing to do with the issues at the trial, and was improper.
But I guess my question is, if you say you really should believe this witness, and there's no dispute that that witness is to be believed, how is it going to affect the jury?
As I say, it's just an accumulation of several of the things that happened during the summation. In and of itself, it's not sufficient. But when you put it together with everything else, the prosecutor kept commenting about certain things the defendant did during the course of the commission of this crime prove that they were rational. They were rational. When rationality is not the burden of proof. It's not the issue to be proven.
One of the comments that the prosecutor made, and I don't think you
I missed one?
referenced it, but no, it seems to me that he talked about one of the signs of rationality was that he had refused to talk to the police at first. It seems to me isn't that improper? I'm just wondering, you did not think that was a problem?
I didn't think that it was a
Yeah.
problem.
It just wasn't one that I think you raised, but maybe you did.
Let me see. I did not raise it.
Okay, all right.
But yes, that is a problem.
When the Commonwealth argues that what a defendant, as they often do in a criminal responsibility case, that what the defendant did was purposeful, planned, premeditated, I understand your argument that that's not the legal standard, it's criminal responsibility, but doesn't that go to the defendant's mental state as to his capacity to engage in rational conduct. Isn't that usually what we have here?
I think so, but I wonder if if maybe as defense counsel, we do a misservice when we don't, during the course of putting forth a mental disease or defect defense, separate people being able to conduct themselves rationally under some circumstances and still be mentally ill.
And I would agree wholeheartedly if the prosecution had said you should find him criminally responsible because, and implied that the standard was rational conduct as opposed to, obviously that would be a departure from what the law is. But how is the Commonwealth supposed to argue the defendant's offense conduct and not comment on the rationality of it?
Maybe they need to interject the word sane instead of rational. It could be just the choice of word. It changes how a jury looks at what they should be looking at to show mental disease or defect or lack of mental disease or defect.
All right, thank you. I think your time is
Okay,
up.
thank you.
Ms. Offering?
Good morning. May it please the court, Susan Oftring on behalf of the Commonwealth. This court should affirm the defendant's convictions where the defendant received a fair trial, where the jury's verdict was consistent with the evidence, and where the Commonwealth proved beyond a reasonable doubt that the defendant was criminally responsible on July 9, 2007, when he committed the 3 crimes against the victims. As this court knows, the defendant was convicted of premeditated murder and felony murder against Aaron Bash and felony murder against Ms. Johnson and armed assault with intent to murder against one witness in this case who testified, Ms. Mercer. Jumping right into the jury instructions, I'm somewhat relieved today that I'm not the only one struggling with the jury instructions on lack of criminal responsibility, but in this case, looking at the criminal instructions as they apply to the issues that were raised in this case and the evidence that came in, there was no substantial likelihood of a miscarriage of justice because the instructions properly informed the jury that the Commonwealth had the burden of proof of proving beyond a reasonable doubt that the defendant was criminally responsible. And how the judge did that is he instructed them that if the defendant was not suffering from a mental disease or defect at the time of the criminal offenses, they were to go no further. If the jury, however, had reasonable doubt about the existence of a mental disease or defect, then the Commonwealth was required to prove beyond a reasonable doubt that despite such a disease or illness, the defendant nevertheless needed the substantial capacity to conform to the law or to know right from wrong. And as this court knows from the record, there was no dispute that between the 4 experts that the defendant did have an appreciation from right to wrong. Really, the dispute came down to if he did have a mental illness.
Well, it's that he doesn't appreciate the wrongfulness of his conduct.
Correct.
Or he's unable to conform his conduct to the requirements of the law. Knowing the difference between right and wrong isn't...
Well, I apologize. You're right. It's to appreciate the rightfulness or wrongfulness of his conduct, but that, the experts agreed, he did not lack that. The only really issue was whether he had the capacity to conform his conduct to the requirements of the law. And if so, what was the cause of that? And in this case, there was no evidence that the source of the defendant's lack of capacity, if there was one, was a mental illness alone. No expert testified that a mental illness alone caused any type of lack of criminal responsibility. The issue was whether it was, and all the experts testified that he had a long history of substance abuse, and there was testimony from the witnesses and from the defendant's statement to police that he had consumed crack cocaine hours, days before, and that is what the jury could have found caused him to
But
have this
I
behavior.
think the argument that the defendant is making is that given that at least as I understand it, given that the mental illness and the consumption of drugs were intertwined for this defendant, the instruction that talked about a latent mental illness when it was pretty patent or was confusing. I think that's the gist, that it wasn't really getting to the point here.
Since this case was tried in 2011, of course, the court, as it explains in DePova, has taken out that language about latent and patent. In this case, though, I think the jury instructions were sufficient that the jury knew that if there was this combination of a mental illness with a voluntary intoxication of alcohol or drugs, they knew two things. That one, drugs and alcohol is not by itself a mental disease or a defect, but if the defendant's voluntary intoxication of drugs activated or interacted with his mental disease or defects such that it resulted in the defendant's loss of substantial capacity, in this case to conform to his conduct to the requirements of the law, the jury knew that the defendant would lack criminal responsibility. But the judge continued, unless, however, there's an exception to that, and that's where, in our case, the jury was instructed, that the defendant knew or subjectively had reason to know under the circumstances that his use of drugs would activate the mental illness or defect, and then he's not entitled to a lack of criminal responsibility. And in this case, there were 3 of the experts testified that the defendant was aware of the effect of drugs and alcohol, would activate or worsen or intensify his mental illness. The defendant said it in his statement to police. Some of the witnesses in this case, the 2 witnesses, Ms. Mercer, who knew the defendant, had known him to use drugs. Ms. Latender had used cocaine with the defendant in the hours prior to the murder, said that his behavior changed.
Right, but what matters is whether he knew it.
Right.
The fact that others knew it doesn't.
I agree, Your Honor, although circumstantially, I think you could infer that if the people in the defendant's circle, his wife, for instance, said that when he wasn't on drugs, he was a good husband, he paid the bills, he cared for the children, and then when he would start to use drugs, and then it was a cycle. She would throw him out of the house, and I think...
I was a little confused. Wasn't it that he would also stop taking his meds and instead use the substances like the illicit drugs and the alcohol?
There was some testimony...
So which is the thing that, I'm confused there about, because if you stop taking your drugs and your mental illness kicks in, is the mental illness kicking in because you have the underlying mental illness that otherwise is treated, or is it the drugs and alcohol that are somehow involved? I'm just very confused.
Well, there was some testimony in this case that the defendant had used drugs and alcohol from an early age. I believe at the time of trial he was, or at least at the time of the crime, I think he was 26 years old. There was testimony from some of the experts that the defendant started using heroin, cocaine, and other drugs beginning ages 14 or 16. So he had a significant history of using drugs and alcohol. The jury also heard evidence from 2 of the defendant's experts that he may have had some type of mental illness, schizoaffective disorder, and hallucinations. The experts were uncertain, though, as to, there was some testimony that sometimes this prolonged use of substance abuse could mimic signs of mental illness, and therefore they didn't have a clear baseline as to what his mental illness was versus what was related to the drug abuse. But there was testimony that to the extent, I think in 2006, when he was treated for the schizoaffective disorder, he had been prescribed antipsychotic medications, and there was some testimony that seemed to help with his symptoms until he went off of it and then began using the illegal drugs, which it appears happened in the weeks before this murder, that he began using the crack cocaine. There was substantial evidence in this case that it was a premeditated murder. The prosecutor thoroughly cross-examined the defendant's expert, the one expert, Dr. Spears, who was the only one out of the four who opined that he was not criminally responsible, but the prosecutor elicited testimony that several of the factors related to the defendant's conduct before, during, and after the crime, just hiding a gun, disposing of bloody clothes, threatening a witness who knew too much, was all rational behavior, and it was unlikely that he was suffering from any mental illness or lacked criminal responsibility. I'd like to just...
I'm a bit confused in terms of when you say that the defendant's statements indicated that he knew that his mental illness would get worse with drugs. What statements are you alluding to?
There was a statement in that he told police that he took drugs that night, and drugs would, and I'm paraphrasing, I don't have the exact thing, but would make me do crazy things, be paranoid, I think was a word he used, have hallucinations, something to that effect.
Now, there are folks who don't have mental illness who might say the same thing. How do we separate the two, or how should the jury have separated the two?
Well, it would go to his knowledge of the effects that the consuming drugs would have if the jury believed there was an underlying mental illness. That goes to his knowledge of what would happen if had he consumed the drugs, which is what DePova instruction basically would cover. And that evidence fits into that instruction, and that's why the Commonwealth argues there was no substantial likelihood of a miscarriage.
Because the evidence is so strong that he knew that it would exacerbate his mental illness, that it didn't matter that the instruction may not have been right. That's your point?
Exactly, Your Honor. Then it wasn't only the defendant's statement. It was three of the doctors, two of who interviewed the defendant, said that he was aware of the effect. And moving on to the second argument about the jury instructions, which I know we've stated that were not objected to. The judge followed the 2003 model jury instructions almost verbatim in describing the elements of home invasion, armed assault with intent to murder.
Those are the MCLE instructions, right?
Correct, Your Honor. He used the words that were included in terms of the home invasion. After he described the elements for home invasion, the judge told the jury, if after considering all the evidence you find that the Commonwealth has proved beyond a reasonable doubt each of the four elements that I have just defined, you must return a verdict of guilty of home invasion with a dangerous weapon. And that's in the instruction. That's
In the MCLE instruction, you must return?
yes.
Uses the word must?
That's the word.
And the model homicide instruction uses the term should.
Should.
But obviously, there's a difference between the SJC's model instructions and the MCLE book. Right?
Yeah. With regard to the defense argument about the lack of instructions on whether the judge should have instructed the jury of when they must acquit the defendant, the defense objection to that instruction, or I should say, raised an appeal. It wasn't objected to at trial. But that only related to 3 of the crimes, and those crimes were armed assault with intent to murder, voluntary manslaughter, and possession of the firearm, not to
Not the home, not to the home invasion?
not to the home invasion. And it's the Commonwealth's position that the judge repeatedly informed the jury that it was the Commonwealth's burden to prove each and every element of every crime, and that the burden never shifted to the defendant. And if the Commonwealth failed in any manner to meet its burden, then they must find in favor of the defendant. And I cited at least 5 to 6 times that instruction was provided. The jury was aware of what the instructions were, and there was no substantial likelihood of a miscarriage relating to those instructions. And lastly, on the last argument raised by defense counsel,
Well, the closing, let's talk about the closing. I mean, don't you think it's somewhat problematic when the prosecutor is saying, don't pay any attention to any of the experts, you shouldn't do it, and it's a crutch, and then some of the things about the point I made about, you know, look at how rational he is. He refused to, he didn't want to sign the card, and he first refused to talk. I mean, none of that is proper, none of it.
I was starting with that one, Your Honor. The prosecutor did point to the police interview, and he did, in terms of whether the jury should find that the defendant was criminally responsible or not, say, look at the
You can't do
interview.
that,
Excuse me?
right? You can't do that.
You shouldn't do that. But the defense also did it. I think both sides looked at that interview to say, look at how the defendant is interacting with the police to help you in your decision of whether he's exhibiting sanity or not. And defense counsel asked that the jury look at the interview and say that the defendant was showing irrational behavior. I think at one point
But that goes to when he agreed to be interviewed. I'm talking about the initial declination of the offer to interview, and I don't think it is proper to use that as a sign of rationality or sanity, which is how the prosecutor referred to it.
He did say that he didn't initially want to talk to the police and then was bargaining with the police at some point, and
Said, more calculation, he knows. I'm not talking to them, pretty smart, he knows.
yeah, if it should not have been said, I would agree with Your Honor, but I don't think it, in light of the totality of the closing and the evidence at trial, it would raise to the level of a substantial likelihood of a miscarriage, especially when defense counsel, again, it was an issue for both sides, and I think at one point the defendant said he wasn't rational, he's asking for a cup of water, and only then was he going to give information. I don't think the defendant, I don't think the prosecutor vouched for the credibility of any witnesses or...
Well, he did say about the one that he said was the only witness they should consider. She's a very moving witness, a very candid and honest witness in all her statements. I mean, I don't know what you call it. I call that vouching.
I wouldn't call it that he told the jury to disregard all the other evidence. He commented that, and I think the witness he was referring to was Ms. Mercer, who was the third victim who shot and survived this horrific crime. In a case where he's basically asking the jury to accept or to believe certain witnesses, and it was proper in that sense. He's not saying that he knows what she's saying is credible, but he was basically almost a rhetorical question that she appeared credible, and the jury could accept that or not accept it. And especially in a case with this where there was no dispute as to whether the defendant is the one who committed these crimes, and that's generally, almost entirely what her testimony was,
To that point.
to that point, exactly.
So
So I would ask-
the defense was a crutch, he's not a raving lunatic.
Keeping the shades down?
Again, I don't see that as improper.
Don't?
I don't,
You don't
was-
think you don't think it minimizes the difficulty of mental illness? That you've got to be a raving lunatic sitting in a room with the shades pulled down?
I don't think he's saying that that's what mental illness is. I think what he's saying is, you have the defense saying that these actions were caused by someone who was, in the defense closing, he said that, and I think he incorrectly quoted Ms. Mercer's testimony, saying that the defendant was psychotic, delusional, shouting and spewing information about Aaron sleeping with his wife. He had a twisted mind. So I think both attorneys were arguing about this issue of how the defendant was behaving on the night of the crimes, and the prosecutor's words, I think in relation to the entire closing on both sides, it was fair.
All right, thank you.
Thank you.